My name is Steve Williams, and I've been doing real estate and landlord-tenant law now for a little over 20 years. And I just sort of want to elaborate and sort of continue on what Brad was saying. And that's the importance, it's an asset protection, a liability protection is the insurance aspect. And I can't really underscore enough the importance of having the proper insurance in place, as Brad mentioned. And so typically when someone comes to my office and asks, hey, I need your assistance with dealing with a tenant, we need to recover possession. The first thing I do before I send out any correspondence or any sort of eviction notice to the tenant, I say, let me see your insurance policy. I want to make sure you have the appropriate coverage in place. And typically what I'm looking for is most insurance policies will include bodily injury and property damage, which is great. You need that. But I also look specifically for what's known as personal injury. So I want to see personal injury in that policy. So those three things, bodily injury, property damage, personal injury, are some of the things that I specifically look for. As well as in California, you can really sue anyone for anything. You can have all the asset protection in place. It's not going to prevent someone from running down to the courthouse and filing a lawsuit. And by having the proper insurance in place, you will, as the first line of defense, hopefully be able to get your insurance company to pony up on the cost for the defense of that lawsuit, and hopefully the ultimate resolution of that lawsuit as well. But because it's so easy and because the liability is so high, I typically want to see also $1 million liability coverage. And sort of to illustrate or put into an example here in the current situation, many of you probably saw in the news you saw the partiers, the spring breakers in Florida, out on the beach, having a good time and just flaunting the current stay away and stay home orders that were in place. And you could have a similar situation with a tenant. Maybe you have a large multi-unit building and you have a tenant who just doesn't care. Maybe they're throwing a coronavirus party, inviting all their young friends over who feel, who are fearless and feel, indestructible. And then suddenly, they're putting other lives in that property in danger. And guess what? Guess who's going to get sued should someone, God forbid, become ill? Should someone end up, becoming seriously ill, maybe even passing away as a result? It's going to be the property owner. It's most likely not going to be that tenant who's the source of the problem. It's most likely going to be the property owner, that the owner, either knew or should have done something about this or to prevent it. Regardless, it's going to be the property owner who gets sued. So again, the importance of the asset protection with insurance and maybe creating specific entities, as Brad talked about, to help shield against that potential liability is crucial. And it kind of underscored by the current events and what's going on right now throughout the world, basically. So let's talk a little bit about some of the laws. So right now, as you're aware, there's a state of emergency, and that's throughout the entire country. Donald Trump declared a national emergency, as well as 48 states. The last I looked was 48 states had also declared states of emergency. And these are important, not just for government resources, but also from these emergencies come about certain laws that may impact property owners. And I'll talk about that in a moment here. In addition to the state of emergency orders, there's also numerous states who've said, you know what, stay home, don't leave. In fact, it's a crime if you leave. You can only leave for certain, important essential activities, that are important to the infrastructure of the community. And here, it looks like there's about 15 states here, including the state I'm in, which is California, which is basically saying, you know what, stay home, don't go anywhere. So that's important. There's laws that are in place and potential. I know some of my, some of the jurisdictions around here are, are actually beginning to enforce these, with criminal, potentially pursuing, criminal liability against individuals who are violating the stay-home orders. And also you're endangering other people by not staying home and heeding the applicable laws. So the resulting state laws, like I mentioned, from some of these emergency orders come some resulting state laws. And I'm speaking for California, and I'm sure other states have similar laws. But for instance, in California, when a state of emergency is declared, that immediately kicks in a criminal code, which says no price gouging. And this is important for property owners because, as you can see on the slide here, one, you cannot give rent increases during the state of emergency that exceed 10%. So you can't gouge tenants by giving them unlawful or excessive rent increases. But more importantly, or as importantly also, no evictions and then re-renting a unit at an amount that even exceeds the displaced tenant. So if your tenant was paying $2,000 a month during this emergency period, you end up terminating that tenancy and then renting to someone else for more than $2,000 a month. In California, that's a crime. It's a violation of the anti-gouging laws. So there are most likely similar type laws in place in your communities or in your states as well. It will vary, but I'm just giving you a broad overview here as to some of the implications of these states of emergency laws. Now, in addition to state, I talked about national orders, then there's state emergency orders and laws in place. There's also local laws. So many cities, like I practice in the Bay Area, as you can see from my background here, the Golden Gate Bridge. Certain cities have enacted additional laws to protect tenants, basically to maintain the status quo for tenants during this emergency period. For instance, in San Francisco, there is a moratorium basically on non-payment rent evictions. You can't evict a tenant right now in San Francisco for not paying if that non-payment was due to the coronavirus. It's very broad, whether it's the person actually became sick or lost their job or any impact. Maybe they can't leave their house because of the stay-home orders. Any impact that is limiting their ability to pay rent, they may very well get a reprieve, at least temporarily, from the obligation to do so. This doesn't mean this is a waiver of the rent altogether, at least not yet. I have heard some advocates here lobbying for just that. I have not yet seen that in any of the local jurisdictions whose laws I've looked into, where it's a straight waiver of the obligation to pay rent, period. No, it's a deferment right now, at least in San Francisco. I know Los Angeles, I believe Hayward, there are some other counties and cities around California as well have similar type of laws in place, but it defers the rent for a period of time until the emergency orders are lifted. And then some jurisdictions even have long-term repayment plans. Like for instance, in San Francisco, and I believe Los Angeles is the same, even after, let's say the emergency laws are in effect until the end of May of this year, and then beginning June 1st, maybe the obligation to pay rent kicks back in again. Well, the rent during March, April, and May be deferred and repaid over a period of time. In San Francisco, it's 6 months. So the tenant would then have a 6-month period to repay that deferred rent. So again, it's all very fluid right now. And I'm speaking as to what I've seen as of today. And different laws are changing, different things are being enacted, and different jurisdictions have different things in place right now. And what is today could be different tomorrow. And what is today through the end of April could be extended to the end of June tomorrow, or at some point in the near future. So, try to stay attuned as to what the local laws are in your area, as well as the state laws. So we talked about sort of what the federal government has done, what some states have done, as well as what local jurisdictions can and have done. Well, guess what? The courts themselves are basically, for all intents and purposes, shut down. So even in most jurisdictions, in order to enforce any lease violation or to litigate any tenant dispute, you got to go to the courts. You can't evict someone, at least not in California and in most states. You can't evict someone without going to court and getting a judgment or an order. Well, the courts are shut down, which for most purposes, for most general civil litigation, there are some exceptions for things like temporary restraining orders and things like that. But for general civil litigation and evictions, you may be able to file something, but you're not going to get a court date. You're not going to get any responses from the other side during any court shutdowns. And the times vary for the shutdowns. Like over in Marin, the last I read, it was through the end of March. I think that's going to be extended much longer than that. San Francisco and Alameda County, which is where Oakland is and Berkeley is, I believe, until April 7th. The courts are essentially shut down. Again, I think that's most likely going to be extended. So we're looking probably for the long haul, where even if you had a dispute and even if the laws allowed you to proceed with an eviction, you just might not be able to because of the inability of the courts to actually, entertain those actions. And I just heard just this morning, I believe it was, from the California Supreme Court that all jury trials throughout the entire state of California are now delayed 60 days. And guess what? Any eviction lawsuit, any landlord-tenant litigation, at least in California, is entitled to a jury trial unless it's at the small claims court level. And I believe that a lot of states are similar. So right now, it's just it's a time where there may not be a lot you can do because of certain state and local restrictions, as well as just the court's capacity to entertain any sort of a litigation or dispute right now. Now, we talked earlier, I mentioned that there's some restrictions in place about failure to pay rent. Well, what can a landlord do at this point? And that's I'm getting those questions from clients left and right over this last week and a half. What do I do when this happens? Or it's already happening. I've already heard from my tenant who's lost their job. For the most part, it appears that the tenants in those situations are fairly sincere about it. I suppose there probably will be some tenants taking advantage, but you need to look to your local laws. Like, for instance, in San Francisco, the tenant's required to provide some sort of demonstrative proof that they're unable to pay. Something that is objectively shows that they can't afford to pay the rent at this point due to the coronavirus. And then at that point, then that triggers the landlord's obligation to work with the tenant. So what I'm at least telling my clients right now is, try to be sympathetic and try to work with the tenant and get, if the tenant offers to pay half, get what you can. Bird in the hand is worth, more than nothing. Don't say it's all or nothing. Try to get something. So if they can pay half, then, again, depending on the current laws in your jurisdiction, you may be compelled to defer the unpaid balance to a later date. So, again, try to be sympathetic, try to work with the tenant, try to get something you can, let the tenant know that you're willing to work with the tenant. And if they can afford to pay anything, try to get that. And that, unfortunately, is really all you can do. And Brad did say some good information, because the other question I'm getting is, well, how am I going to pay my mortgage? How am I going to be able to afford my business? And Brad gave, some good information there with some resources as to who to reach out to. And I know also just today, there was mentioned also sort of the recovery plan, the infusion of money that's going to be out there allocated for certain things. And I know a portion of that money is earmarked for small businesses. So perhaps there will be some money there as well for those who are in the rental business who are taking a hit because their tenants can't afford to pay rent. But right now you're going to have to work with your tenants. The other big question I get is the first one is, like, my tenants aren't paying rent, or they're not going to pay rent, or I'm concerned about that. The other is, and we talked about this just a moment ago, is a tenant who is just flouting the rules, just endangering other people in the in a building or in the neighborhood, creating a nuisance in essence. Well, nuisance is a ground for eviction, even in rent control jurisdictions. If a tenant's creating a nuisance, that's a basis for eviction. And that right now is a nuisance eviction is not one of the protected types of evictions in the jurisdictions I've seen, where a landlord can still proceed against a tenant for sort of a tenant's conduct type of evictions, like a nuisance or illegal activities. So if it's given rise to that, if the tenant's conduct has given rise to that, like I suggested earlier, throwing, and I just read about this today, someone threw a young 20-something individual through a coronavirus party. They had their friends over. If things like that are going on and endangering other people, then you may be able to take steps at this point, and probably should take steps to protect the neighbors and the other tenants in the building from potential liability. And like I said, you can still proceed with that type of eviction with any sort of notice or warning. But again, the problem is the court's capacity. You may not actually get to litigate it, but at least at this point, you can put the tenant on notice and do everything that you can to get the tenant to stop doing that, and possibly even evict the tenant. But certainly, at a minimum, I believe that taking steps and being proactive as a landlord at this point to, one, work with your tenants who may not be able to pay the rent, but two, to also ensure the safety of the other tenants. In fact, at least in California, and again in most states, a landlord has a duty or an obligation that's inherent in all contracts to actually provide quiet enjoyment to their tenants. And so part of that would be, ensuring that their safety is not jeopardized by other tenants, and to potentially take steps to take action or to prevent that. And also, you can always refer any tenant who is complaining to you about this or concerned about this, about maybe one of their neighbors, to, well, look, if they're out violating these local orders, these stay-home orders, or they're out, touching things in the common areas, or doing things they probably shouldn't be doing, well, maybe you can call the authorities. I hear about situations where neighbors hear their other neighbors coughing and calling the police for something like that. Don't waste, put the police resources on things like that. But if you have a legitimate concern about someone potentially creating an endangerment to others in common areas of the building, then not only notifying the landlord and let the landlord do what they can to address it, but also potentially notify the authorities. Finally, the last thing I want to talk about, and it's not here in the slide here, but and Brad and I talked a little bit about this yesterday. It's this term or phrase, what's known as force majeure, which is a party to a contract may be able to get out of a contract as a result of some act of God. And I've seen this now on a couple of occasions. I'm not seeing it in the residential context, although I could foresee it, where a residential tenant wants to get out of a lease because of the coronavirus. Usually it's the exact opposite. They want to stay in the lease. They just want to defer the rent. But it has come up in a couple of different contexts that, well, hey, a tenant could try to back out of a lease. Maybe they just signed a lease and they're a month into it and they want to move back home with mom and dad or something like that. So they use this act of God, which under state laws as well as contract laws, a party to a contract can get out of a contract as a result of an act of God. The traditional example of an act of God might be like an earthquake. That's the prime example that I see here in San Francisco in the Bay Area is an earthquake could certainly frustrate the ability to perform a contract. But generally, it really has to result in a sort of an impossibility or an extreme impracticability to perform the contract. And in my initial analysis, it doesn't appear to me, at least, that this coronavirus and losing one's job is a basis to void a contract under these force majeure laws. But as I mentioned to Brad yesterday, you're going to get a lot of creative lawyering out of this, and who knows, what the laws will, how they'll come about and how they'll be interpreted going down the line. But it is certainly just something to think about. But like I said, initially, it just doesn't seem to me that someone losing a job as a result of the coronavirus is akin to an act of God creating an impossibility to perform a contract. But I just wanted to mention that and let you know that may be something that you encounter at some point, and you'll definitely want to consult with a lawyer about that and about these other issues as well, and just stay up to date and in tune with what the laws are in your state and in your local community.